Thanks, Walter. As folks mentioned, my name's Ben Travers. I'm an associate attorney with our labor and employment group based in Burlington. Uh, Beth and I and our employment group have been busy these past few weeks for all the wrong reasons, having to help employers in all industries deal with some of the toughest decisions in both their business and personal lives. And I know that the last few months have hit the hospitality industry particularly hard. Personally, I've been following and was happy to sign on to your Don't 86 Us petition, and my family has otherwise tried to make an effort throughout all this nonsense to regularly get takeout and delivery from local establishments, and I'm excited to see that many of you have been able to open back up a bit here. But I also, of course, recognize that you've had to let people go or furlough people or whatever the term you may use, as Beth just went over, and that others may be considering having to let even further people go here in the future. So some additional considerations to consider on top of what Beth just mentioned. The first I'll go through very quickly, and the reason why I'll go over it is because it might apply to a couple of you, or if you have been Googling or looking at other resources as to what you need to consider in going through layoffs, one of the things that may come up is referred to as the WARN Act. The reason why I say it may only apply to a couple of you is that it's a federal law that only applies to employers of 100 or more employees. I think there's only 100 or so employers in the state of Vermont with 100 or more employees, but nonetheless, this is just a brief primer with respect to what it is. The WARN Act, from the federal law standpoint, requires that employers give 60 days notice of a plant closing, which would basically, it's termed in sort of manufacturing plant factory, but that term plant would apply to a restaurant or to a hotel or to a bar or really any single establishment, or a mass layoff. And it requires that notice be given not only to their employees or any employee union, but also to the state dislocated worker unit in Vermont, that's the Vermont Department of Labor, as well as the chief elected official of local government. So here in Burlington, for example, the WARN Act would require that you give notice to the mayor. In some other towns, that may be the select board or a town manager, as an example. Now, there is an exception to that 60-day notice period for unforeseeable business circumstances. Many employers that are required to give WARN Act notice, of course, when COVID-19 came around, were unable to provide that 60-day notice. And there's a pretty good argument to be made that that was because of unforeseeable business circumstances. But just because you may have those circumstances does not waive the requirement that you provide this notice. You're still required to provide the notice to the greatest extent that you can. And the WARN Act looks at employment losses during 30 and 90-day periods. And this is enforced by the courts, such that if employers fail to provide that 60-day notice or fail to provide it as soon as they're able to in the event of unforeseeable circumstances, employees could sue their employer for not providing that notice. Again, just very briefly here, when the WARN Act refers to what an employment loss is, it's really referring to a termination or a layoff that exceeds more than 6 months, right? So many employers have had to let folks off temporarily. And if that temporary layoff or furlough is not extending beyond 6 months, then you don't need to worry about the WARN Act. And the other thing is that if you are an employer that's covered by the WARN Act, meaning under federal law you have more than 100 employees, your employment loss needs to have affected more than 50 employees over that 6-month period. And as well, that number needs to be at least 1/3 of your workforce. Now, the sort of last thing I'll mention here on the WARN Act is that if you have had a short-term layoff or a layoff that you thought would be short-term, and it's becoming clearer that may now be extending beyond 6 months, then you would be required to provide this WARN notice under those circumstances. Again, I very much doubt that this is applying to very many of you, but thought we would provide a primer. There is also in Vermont their own version of this law, which folks many times refer to as sort of a mini WARN Act. This applies to employers with 50 or more employees. So unlike the federal law with 100 or more employees, the Vermont law applies to employers with 50 more employees, and the requirements are largely the same, right? It requires that you provide 45 days notice to the state and 30 days notice to employees, their union, or the local chief elected official. Similar definitions here with respect to what a mass layoff here as to what triggers it. It's a permanent employment loss of at least 50 or more employees at one or more sites during a 90-day period. So it's more likely that for a Vermont employer, the Vermont Mini WARN Act may apply than the federal law. But as we've all been going through these COVID-19 circumstances, the Vermont Department of Labor has made clear that they are not actually enforcing the Vermont Mini WARN Act at this point in time. If it applies to you, it's still to your benefit to err on the side of caution and to provide notice, but just know that if you're having a whoops moment right now, thinking that you should have done this in the past, the Vermont Department of Labor, which is the entity that would enforce the Vermont law, has said that they are not enforcing it at this time. So that's it with respect to the WARN Act, which now takes us to some unemployment considerations, which may be the issue that's of more interest to you all. So as I suspect many of you know, the Vermont unemployment law was changed after this pandemic started. There was a new law signed on March 30th of 2020 that really expanded the circumstances under which Vermont employees would be eligible for unemployment benefits. And one of the biggest ways in which it did that is that historically speaking, if an employee were to voluntarily quit their employer, they're typically not considered to be eligible for unemployment benefits. However, now, if an employee voluntarily leaves because they're subject to a quarantine order, either from their healthcare provider or from state or federal government, if an employee has to leave because they have COVID-19 symptoms or have been exposed to someone who has COVID-19, if they belong to a high-risk group and have to voluntarily leave because of that, or if returning to work would present an unreasonable risk of being infected with COVID-19. And then finally, if an employee is voluntarily leaving because they have to care for an individual who fits those earlier circumstances, or to care for a child whose school or care facility, which now that it's summer, could be a camp or something along those lines, if they have to leave for those reasons, those folks, even though they're voluntarily leaving, may be eligible for unemployment benefits. However, if an employee voluntarily leaves, the employer is relieved of charges to their experience rating. And that term experience rating is the figure that determines how much an employer has to pay into the unemployment system in taxes. So if an employee voluntarily leaves, even if they're eligible for full unemployment benefits, you as an employer should not see an impact on how much you're having to pay into the unemployment system. The other change to the unemployment law with respect to these experience ratings is that employers are also at least temporarily relieved of changes to their experience rating if they had to lay off employees because of business circumstances related to COVID-19. I suspect that obviously many restaurants, bars, and others in the hospitality industry, of course, had to lay off their folks for reasons related to their coronavirus. And those employers should be relieved of charges to their experience rating, but there is an important exception to that, which is that in order for that relief to remain in place, employers, as they reopen, need to extend job offers back to those who they previously laid off. So if you have laid off someone because of the coronavirus, they receive unemployment benefits, and you do not extend an offer of reemployment to them, you could end up seeing a change to your experience rating. So an important exception to remember there. And again, you just need to make the job offer. If an employee then turns the job offer down, you have satisfied your obligation to at least attempt to rehire that individual. The other thing I would note for folks on the call is that now, just as in the past, past employers may still see experience rating charges. And what I mean by that is if you had an employee a year ago who you terminated or who left for reasons completely unrelated to the coronavirus before this was even on our radar, and then they left and they got another job somewhere else, and then lost the job from their new employer because of the coronavirus, the State Department of Labor looks back about a year to determine what someone's unemployment benefit should be, and they look at wages that they've earned from past employers. So you may be getting some things in the mail from the Department of Labor indicating that your account is being charged for an employee who left you a year ago, and wondering, what's going on with that. So that would be the reason for that. I've put here sort of in red and bold and underlined to look out for incorrect charges, because I have heard that when the Vermont Department of Labor recently switched over to an automated system to try to process all these claims they've been going through, that the system has sometimes been mistakenly charging past employers where they should not be charged, right? So if you're a past employer and someone voluntarily left you, you should not be charged for anything. Even if you paid wages to that employee within the past year, you shouldn't see any changes to your experience rating. But I have heard that there's some glitches in the Vermont Department of Labor system here where they've been mistakenly charging past employers. So be careful about that. If you see some notices coming in that don't seem right to you, where you have an employee who you think or past employee for who you think you should not be charged for, be very careful for that. And certainly if you have any questions about it, feel free to reach out to us. Finally, the last thing that I would mention on this, and this has been a question that a lot of employers have been asking as they reopen, is what if an employee doesn't want to come back? The unemployment system has been relatively friendly here over the last couple months or so, with new federal benefits that, on top of the Vermont law, gives employees an additional $600 a week. What I can say to that is that Vermont has said that if work becomes available and it's safe for an employee to return, that if an employee then refuses to return to work, that may then disqualify them from receiving benefits. And again, as I mentioned previously, you should receive, if an employee is being charged for benefits onto your experience rating, you should receive something from the Vermont Department of Labor outlining what those charges are. If you get that for an employee who you have offered work to and they have refused it for one reason or another, there are instructions on that form as to how you can inform the Department of Labor that you offered that work. As I mentioned previously, over the past couple months, there has been, under the Federal CARES Act, an additional $600 per week available for COVID-related unemployment. That will remain in place through July 31st, but that additional $600 a week will not be available to employees after July 31st. There's been some efforts in Congress to extend that, but not as of yet. There's some additional information here with respect to nonprofit employers, and many nonprofit employers in the state are actually self-payers. Their employees receive unemployment benefits through the employer itself and not through the state unemployment system. I don't think that applies to very many people on this call, but certainly there's information there if folks want to read through it.